I like Anchorman better though, to be honest.
I think I prefer Step Brothers, so Step Brothers.
God.
All right. Board council again, repetition circuit non-session. The honorable judge got back to decide for come on.
Thank you. Please be seated.
Good afternoon, Judge.
Good morning, Mr. McDougall. Anyone heard from the state? What did I say? Who knows?
I was not going to be the one to correct you.
Feel free. All right, good afternoon. And just a reminder,
Good afternoon, Judge.
we're going to try and start on time. All right. So please try to be in here next time when we're ready to go. Let's go on the record then. This is 23SC188947, State versus Jeffrey Clark. We're here on Mr. Clark's motion to compel. And if, just again, for the record, let's have counsel announce themselves as well as whether the defendant has expressly waived his presence.
Harry McDougall, Your Honor, for Mr. Clark, and he has expressly waived his appearance at the hearing.
All right. Thank you, Mr. McDougall. Who's arguing for the state?
For the state, Alex Brennan will be arguing.
Okay. All right, Mr. McDougall, your motion, sir. I've read it. Tell me what we ought to know.
Okay, so we've got two categories of documents that we're asking for. One is the state's two-way correspondence with the federal government, and the second is any documents reflecting their communications with the White House about this case. So I'll take the first one of those first. If I'm telling you something that you already know, please stop me. To set the table, to bring a former federal employee into court to testify, you have to, the federal regulations require you to comply with what are called TUI regulations, which are named after a case involving a guy named Tui. You make the request, the agency applies the criteria in their regulations, they say yay or nay and give their reasons. If they say yes, they will normally reserve some areas or topics where the witness is not allowed to testify, and things like a privilege of one kind or another. It might be executive privilege. It might be law enforcement privilege. It might be classified information or national security. We're asking for their TUI correspondence because we believe the federal government's response will be helpful to the defense and may be material to the outcome of the case. And we believe that is true whether TUI clearance was granted or refused, and I will explain that. If it was denied, it will tell us if the key witnesses to prove the state's case against Mr. Clark are available to testify at all. And if they are not available to testify at all, that would mean the state would be unable to prove their case against Mr. Clark. And obviously that would be material and helpful to the defense. I don't know if that's the case, but we have reason to believe that it might be, which I will explain. It was reported in the New York Times that the DA's office had asked for TUI clearance for Mr. Jeffrey Rosen and Mr. Richard Donahue to testify to the special purpose grand jury. Mr. Rosen was the acting Attorney General of the United States at the times relevant to the charge, and Mr. Donahue had a much more complicated title, but he was number 2 at the Justice Department. So the New York Times said the DA's office asked for TUI clearance for those gentlemen and was refused. We attached that article to our motion. Now, in citing the New York Times, I do not want to get a rumor started that I believe everything in the New York Times. However, that reporting was basically confirmed by subsequent events, which just became clear at the end of December. The special purpose grand, those two gentlemen did not testify to the special purpose grand jury in person. Instead, the special purpose grand jury was shown videos of their public testimony before the January 6th committee when they had a televised hearing to bash Mr. Clark. The list of special purpose grand jury witnesses have a little notation out to the side for those two gentlemen that said video presentment review. And I didn't know quite what that meant, so I asked them because I wanted to confirm one way or the other whether they had testified to the special purpose grand jury and try to put some meat on the bones of what the New York Times had reported. And I began to get the idea that they really didn't want to tell me that because I had to ask them 4 times over the course of a month before they finally told me. And they finally said on December 27th, as to Donahue and Rosen, the jurors reviewed the video of their testimony. They did not appear before the jurors in person. And they subsequently clarified that that was referring to the January 6th public testimony. So chalk one up for the New York Times. It confirmed, or seems to confirm, that the TUI request was denied. That supports the inference that it would also have been denied for trial testimony. And that might also be the case for other DOJ witnesses, such as Ken Klukowski. Rosen and Donahue are essential witnesses for the state on count 22 of the indictment, which is the predicate crime charged against Mr. Clark for attempted false writing, whatever that is. If the state cannot get their testimony because the TUI request was denied, the state will not be able to prove their case on that charge and maybe count 1 as well. Knowing that, of course, would be helpful to us, materially affect the outcome of the case. So we're entitled to it. The correspondence is not privileged, so we're asking you to order that. So let me talk for just a second about what if it was granted versus if it was denied. If it was granted, the privileges are still reserved, often. They might have reserved for executive privilege, law enforcement privilege, and classified information. Those would be very significant points for our case, for our defense, because we are asserting all of those privileges. That's part of our defense. The conduct alleged against Mr. Clark relates to discussions that he allegedly had with the number 1 and number 2 officials at the Department of Justice about whether and to what extent to assert Article 2 law enforcement authorities. If those privilege limitations are set out in the TUI clearance letter, it would support our arguments on those privileges. And the same is true for any reservation with respect to national security information. If the government's witnesses are barred from testifying on those topics, these witnesses, Rosen, Donahue, Klukowski, or any other federal government witness, it would limit the state's ability to prove their case at a minimum. But it would also, and more importantly, limit Mr. Clark's defense because his defense relies on topics that are within the scope of those privileges. So those would all be very good reasons to deny the TUI request in this case. But if they were granted, the terms, conditions, and limitations are going to be important and likely to be helpful to us to know what might be coming, and they might materially affect the outcome of the case. Now, if the requests were denied, the reasons that would be given for the denial are also likely to be right in line with our arguments in this case. It stands to reason that and I don't know this, okay, but this is inference. The federal government might have denied the request based on federal supremacy and immunity doctrines in combination with the privileges that I have mentioned. It would be helpful to our federal supremacy and immunity arguments if the Department of Justice were taking the same position. Now, if their TUI requests were denied on those grounds, I could certainly see why they wouldn't want me to see it. But they should be required to produce it. If it was all in their favor, they'd be cramming it down my throat. So that is the argument on the TUI correspondence. And I'll now go to the White House contacts unless you have questions, Your Honor.
Yeah, let's dig into that a little bit, and maybe it'll make more sense to divide these up. So I certainly understand the legal strategy and the point of view you're coming from. What I'm less clear on is that there is a legal remedy at your disposal. So just kind of taking it step by step.
Sure.
Would you, I think you kind of hint at this in the motion, would you concede that as a statutory matter, these wouldn't fall under Georgia's statutory means of discovery? Is that fair to say?
I think that's right. The language of those code sections is limited in a way that I don't think this can be fit into it.
Okay. So we're solely in the ballpark of Brady.
Brady and due process generally.
Okay.
Your Honor.
And so then the first thing that I guess the hurdle to clear with Brady is when it becomes due. And so you cite some Ninth Circuit case law to me in your motion. Would you agree with me that the Ninth Circuit case law you cite is not applicable in Georgia? And in fact, Georgia's gone the other way.
And, you know, if you're reduced to citing Ninth Circuit authority, then this means you can't find something else. So I concede that readily.
Okay.
So my argument is that it's exculpatory. This information is exculpatory. What's the definition of exculpatory? And
Well, but before we can even get to that, we have to talk about when. And so purely on the issue of when, the Ninth Circuit says Brady becomes ripe before trial.
right.
But from what I can see in Georgia, they've not extended it that far. They've always said Brady becomes due when trial starts. Is that your read of the land as well? Where does that leave us then?
Well, I think to be fair in the case, I mean, the Brady doctrine originates in due process. Okay, so we're not in a stovepipe, we're in due process land. We have a motion deadline coming up. If the Department of Justice has told the DA's office, you can't have these witnesses because it is offensive to federal supremacy and immunity, that would be pretty good for us on the motion. And so to be fair to us, to give us due process of law, we should have access to that evidence. And that's evidence that would strongly support. I don't know what it says. It might say, you know, you got a free shot. But if it does say that, we would have arguments to make about that.
And this was also something I think I brought up with Ms. Bernard last week, which is let's take out the complications of TUI and the federal guidelines. If this was just the type of murder case that we hear every week here in Fulton County, where a defense attorney says, I need to know whether the sole eyewitness is going to be there at trial next week, because if he's not, then we should roll forward because I don't need to take this generous deal the state's offering me. That would never be granted, would it? How's this any different than that?
Because it would be a legal unavailability of the witness, as opposed to the witness has run away or the state is deciding whether to call them. I'm not asking you to take somebody on a may call list and tell me whether they're really a will call witness. I'm wanting to find out, is the witness available at all?
Never. And remind me with TUI though, can that be decision revisited at any point? I mean, up until the day they're scheduled to testify, could the Justice Department say we changed our mind, the witness is cleared?
Well, I suppose they could. The federal supremacy would allow them to do that, but the federal supremacy issues in the case are significant for Mr. Clark. And if they took the position they're not allowed to testify to a special purpose grand jury, there must be a reason for that. And I don't know what they said. I don't know what their thinking was, but it could certainly be any of the reasons that I've given you.
Mm-hmm.
And if that was their reason then, what would change about any of that now?
Okay, so the distinction you're saying is that this is more an issue of legal unavailability versus your run-of-the-mill case would just be logistical unavailability?
Yeah. So it's like, imagine if the
What
witness,
if that eyewitness in the murder case had fled the United States and they're beyond extradition, they are legally unavailable.
if
It's the same issue?
prosecution knew that, I think they'd be obligated to tell the defense because it would mean they can't prove their case. So it's like if the witness was dead and the government knew it and we didn't.
All right, that's another good example because that has I mean, a dead witness, that has to have been something that's been litigated before under the context of Brady.
I
Have we found
haven't
a case
found
like
it,
that?
but I will take another look but I will give you the caveat. There are movers in my office right now. So we're a little out of pocket, but I'll see if I can find something on that.
All right. Why don't we split it in half then, and
You
let's
wanna
hear
hear
from the
from
state
them?
on that
Okay.
issue. All right, Mr. Bernie.
Yes, Your Honor. With respect to the DOJ two requests, those were communications about logistics and procedure. Brady does not require the disclosure of communications of logistics and procedure. Brady requires the disclosure of exculpatory evidence or impeachment evidence. So what we're talking about is evidence. We're not talking about whether a witness could show up, whether how does a witness get here, what the scope is. We're talking about what the witness said, what they might have seen, how their testimony might change. Further, we're also talking about with this is that the communications, he speculates that there might be contents about privileges that might help his defenses. That's legal argument. That's not evidence of any type that would help his trial. And as we go to Georgia law, you're right, Brady requires disclosure at the time of trial because it's about what evidence what evidence is shown, what can be rebutted. It's not talking about legal argument. I mean, legal argument is at best persuasive to the court and might be more like akin to an amnesty brief, but it's not evidence itself. Any questions?
Have you found the dead witness Brady case by chance?
I have not found a dead witness Brady case either. I have not seen it. I wasn't looking in that direction. I'm sorry.
No, I think that might be worth following up on.
I'll follow up with it. I will say I haven't found any cases, nor has he cited any cases that legal argument or persuasive authority is admissible under Brady or disclosed under Brady.
And setting aside the legal merits, is there anything that the state would like to declare as it relates to TUI in this case?
Declare that this was relevant just to the logistics and procedure as to the special purpose grand jury. We only had, with the DOJ, it was only to the SPGJ, not towards trial. So we'd have to reissue a new subpoena, a new TUI request when it comes to trial.
And
So
are the
it's premature.
guidelines any different when it comes to the DOJ considering it under the auspices of a trial subpoena versus a special grand jury?
Well, we'd have another shot at it with the DOJ. Not to get into the contents of what was in our communications. We'd have to reissue with the DOJ a new subpoena, and they'd have to make their own decisions on what's the best what was the best course of action for DOJ and their agency and their course of interest as opposed to a trial versus a special purpose grand jury or just a regular grand jury.
And again, it's been a minute since I've had to look through that sort of thing, but is there also a remedy if the DOJ denies TUI clearance? Can that be appealed in federal court?
I believe so. I'm a little uncertain, but I think it would be under the Administrative Procedures Act that you could have that judicially reviewed.
So even if you've been denied, that may not be the final word.
And I can.
I think that's more just for my own benefit. I don't think that's really material to the decision today. All right. Well, I'll turn it back over to Mr. McDougald. Any final thoughts on that, sir? And then you can transition over to this White House correspondence
So just on
issue.
the remedy, if you don't like the TUI decision, is you can file an action in the court in DC or wherever the decision is made under the Administrative Procedures Act, but your standard of review is going to be arbitrary and capricious or legal error. So it's pretty tough to win those. It sounds like they haven't made a request for trial. He didn't say that affirmatively, but it sort of sounded like that. But they did make a request for the special purpose grand jury, evidently, and it was evidently denied. So that is very likely to have meaningful information for our case. And, you know, the point he makes about what's the scope of Brady, there's something to that, but the definition of exculpatory that we quoted in our filing, that's the 11th edition of Black's under the tender mercies of Brian Garner. But the definition was when the evidence may be material to the outcome of the case. And if you.
But I guess that included in the definition is what is evidence?
Yeah, what is evidence?
Is someone
And,
going to be in a place or not going to be? Is that evidence or is that logistics?
But it's sort of a phenomenology problem. Here it goes to the absence of evidence, which is an evidentiary point. And if the state knows that it will not have sufficient evidence to prove the case against Mr. Clark, we ought to be entitled to know that now instead of being put through the agony of all of this, being indicted and publicly, subjected to public ridicule the way that.
Well, I guess that'd be the other question I could have asked Mr. Bernick here is you mentioned count 22. And can you even be so confident that the state can't prove its case without these witnesses? Or are there other hearsay exceptions? Are there other aspects of this? And RICO being so broad, is count 22 even necessary to prove count 1?
Well, those become less certain as you go down the line, but to prove that it's a false writing. I mean, look, this is not a new story. We're litigating the exact same theory in Mr. Clark's bar case where he's charged with attempted dishonesty. And the explicit argument is that Rosen and Donahue said that the things in this letter were not so. And they would not agree to the letter. They were against it. They hated the letter. Okay, fine. Well, who is going to put on testimony of what they said to Mr. Clark? It's them. It's them. It's not anybody else. And so if they can't put them up, that they can't prove that. And that's assuming and crediting that attempted false writing is a viable legal theory.
Does it have to be proven false with their opinion? Couldn't it just be proven false by other evidence? Even if they believed it or disapproved of it or thought it was not
The
in the best
linchpin
interest.
is that they told him. That's the linchpin of the attempted falsity. Because the indictment alleges in count 22 that he went back to them after having been told. So the having been told part is essential to the proof in this case, as it is essential in the proof of the bar case. The bar case, they've provided more detail on how they expect the evidence to unfold than the state has, but that's how it's going to roll.
Okay. All right. So let's talk about your part 2, White House communications.
Right. So we know that there were contacts between the White House and the prosecution team because Mr. Wade's billing records that were filed into the Mike Roman motions show a conference of White House counsel on May 22nd of 22, and another conference at the White House, I believe, in November 18th of 22, which brackets more or less the work of the special purpose grand jury. They were impaneled on May 2nd of 22, and I think they heard their last testimony right around that November timeframe. The reason that matters, Your Honor, is the obvious political dimensions of the case. The DA was already disqualified from investigating or prosecuting Burt Jones because of a political conflict of interest, because she was campaigning for his Democrat opponent using the imprimatur of her office. So the DA's politics were already in this case on a de jure basis long before the indictment was even issued. The White House has its fingerprints on all 4 criminal prosecutions of President Trump. And now we know they have their fingerprints on this case. President Biden is reported to have complained that the Department of Justice was taking too long with the case against President Trump. And he said at the White House on November the 9th of 2022 that he would pursue every constitutional means of stopping President Trump from taking power. And that was 9 days before the November 18th meeting at the White House reflected on Mr. Wade's bills. The criminal cases against President Trump are being pushed to have their trials before or during the election. The DA in this case is pushing to have this case start in August. And according to their time budget, that means that it would be tried while voting was occurring. A reasonable person might view the whole picture as having a political purpose. And in fact, a lot of people in this country view it that way according to opinion polls. And certainly most Republicans view it that way, assuming they're still entitled to have opinions. So those communications with the White House are relevant to a potential selective prosecution or due process defense in this case. And as for Mr. Clark, one reason we are a little suspicious about politics is we cannot find any other cases where a lawyer or anybody else, for that matter, was prosecuted over a draft letter that was never sent under a theory of attempted false writing or attempted false statement. I haven't found a case where that happened in Georgia, nor anywhere else. Maybe it's out there, but I haven't found it yet. So that alone, when you can't explain it, when it doesn't make any sense, there must be some other reason. It is reasonable to infer that it's politics. So we're asking the court to order them to produce those documents in addition to the two-week correspondence. Now, I expect what we're going to hear is what we heard on President Trump's motion, that there aren't any documents, but they haven't said that yet, so they get a chance to come up and respond to that.
Okay, well, we'll start there then.
All right, thank you, John.
All right, Mr. Burnick. So let's start there.
Again, we're traveling under Brady, and he's asking for evidence, and our communications with the White House counsel's office was about logistics and procedures, whether they had a TUI type process in place. It wasn't about obtaining any type of evidence from them.
But this seems a bit different. We're not talking so much about the logistics of witnesses as to whether there is potentially any coordination or a political motivation that might.
Well, that's speculation.
And it would be speculation right now because I think he concedes he doesn't have access to your emails, and it would be unlikely unless he was sitting in the room or bugged it that he'd have any idea what was in there. But apparently he's got some documentation that a meeting did occur.
I mean, yeah.
And so I guess the issue would be a selective prosecution claim can be brought pre-trial if they think that there are grounds on it. And that's a bit different than just asking about whether a witness is going to show up or is not going to show up, right?
Correct.
So the original question was, is there something actually in writing that shows communications between the office and the White House counsel?
We did get a letter from the White House counsel's office.
All right,
It was
so
about logistics and procedures, as stated before.
all right, so it's just that you're saying the sole written communication, whether by text, whether by email, whether by written correspondence, solely consists of one written letter.
Written letter, well, there's two written letters, Your Honor, about procedures, about how we interviewed, whether it was a TUI type process with former or current White House officials.
Okay.
Can I?
Yeah, go ahead.
We're talking about selective enforcement here, and let's just go to what you need to prove with a selective enforcement action. In Georgia, for there to be a constitutional violation, selective enforcement must represent any intentional and purposeful discrimination, which is based upon deliberate, unjustifiable standards such as race, religion, or the arbitrary classification. Georgia also recognizes that just because there's a first time prosecuting someone under a statute, or there's the first time that someone might have been prosecuted under a statute that's been on the books for a long time, that does not give rise to a selective prosecution. And also, while we're talking here about his reasons for wanting these items, his reasons for wanting these items are inconsistent with each other. On one hand, he's talking about us talking to the White House counsel's office, them aiding us and having a selective prosecution, them directing us towards a prosecution. On the other hand, we're talking about DOJ hampering us and not letting us prosecute the people that they told us to go prosecute. So his inconsistent theories are going at it. He's just trying to get any way under the sun. And just to recap, these are about logistics and procedure. This isn't evidence. This isn't anything that is obligated to be disclosed under Brady.
Would you agree, though, that Brady doesn't necessarily have to be evidence that on its face is material, but something that could lead to material evidence? So it just has to initiate that chain of discovery.
It could initiate the chain of discovery, but in the end, it has to be about evidence or what's coming out.
Sure. Okay.
Or,
And so if this created some kind of lead, would you agree that a selective prosecution is a viable claim? There are a lot of hurdles, and I don't think that they've jumped any of them in this as alleged in this motion to compel. I think they'd have to show disparate treatment among other similarly situated potential defendants. That hasn't even been alleged. But a selective prosecution is a real claim.
it is a defense that's viable in Georgia.
All right. And that's one that would have to come up before trial because a jury would never get to hear any of this.
There is case law that says it is a pretrial motion, yes.
All right. And so, Mr. McDougall, let me just emphasize that. This argument you're making about selective prosecution, would you agree that that is something that doesn't go to the merits of the case at all? That's not something a jury would ever hear or be able to consider?
Well, I mean, part of my argument is the case has no merit and he's being prosecuted because of politics. So the merits and the selective prosecution argument are joined. But I think I want to reserve the right to change my mind, but I think that's what you said is right, that it wouldn't go to the jury.
Okay. Because, I mean, effectively, otherwise, you're arguing for nullification. Is that fair?
Yeah, which, you know,
I guess we'll address that if we get there.
import in a storm, Your Honor.
So what I'm getting at is also coming back to the original point, which is the timing of Brady. You know, it's usually supposed to be at trial. But however, there's the caveat unless earlier disclosure would have impaired the defense, right? And we're kind of in the situation where this is a pretrial motion that they have to make. And by the time you get to trial, perhaps it's too late to even make it. So point being is in situations where the materiality is even somewhat up to debate, I think the proper procedure is an in-camera review. And if you're saying there are two letters that exist, then it seems that those could very easily be submitted under seal. We can see if there's anything in there even remotely resembling something talking about political prosecution or selective prosecution that would further the investigation of that. And if so, then that resolves this motion to compel. Any reactions to that, Mr. Burning?
I think it doesn't allow them to root around in our files, which is not required under Brady, and that is the remedy for a plausible claim under Brady is to do an in-camera inspection.
All right. Anything else then you think would be relevant to this issue?
No, Your
Mr. McDougall?
Just a couple points, Your Honor.
Sure.
So I learned something I didn't know, which is that there are letters. The second meeting in November doesn't say it's with White House counsel. It says DC White House. So maybe it was with the White House counsel's office, but you can't tell it from the time entry. The way Mr. Burnick described it is a TUI-like set of considerations at the White House. The White House does not have TUI regulations. Okay, so what considerations would there be? It would have to be executive privilege. It would have to be. So their position on executive privilege, if it's articulated in that correspondence, is something that we know what their position is with respect to congressional committees, with respect to the criminal prosecution, but this is a state prosecution.
I think we're going back to
The government and these privileges are much, much different in this form than they are in those forms.
Well, let me make sure I'm clear here, though. The original motion to compel, the request is copies of all communication with White House counsel's office, right?
Yeah, I think I did say that.
And so that's relevant solely as it relates to building a claim for selective prosecution?
Well, I've learned something that I didn't know, Your Honor,
Okay.
in this hearing, which is that the letter is a TUI-like dialogue. And I think we ought to get that too, for all the reasons I gave as to the other TUI correspondence. And the TUI correspondence is not just with DOJ. There are other federal agencies that have former employees with knowledge relevant to this case who are on the state's witness list. Like the former head of CISA, Cyber Infrastructure Security Agency, people like that. And we might want to put up the former director of the Office of National Intelligence, Mr. John Ratcliffe. So
That actually reminds me of a point I meant to ask you on part one. Were you saying that you were needing the testimony of Rosen and Donahue because you believed that would help your defense?
no, I'm sorry, Your Honor, if I wasn't clear. From what we know, their video testimony was presented to the special purpose.
You would be
grand jury.
fine if they didn't show up in court, is what you're telling me.
I'd be thrilled
Okay.
if they didn't show up.
All right, I just want to make that
I don't
clear.
think I would have to show up either.
Okay. All right. All right. I understand the point you're making on TUI. I'm still struggling to see how that fits into Brady, but I'll take a look at the case law
And, you know,
and we'll see.
I know it's not binding on the court, but we did cite to a section of the Justice Manual that that exculpatory information should be provided so that it's useful in time for motions. And that's consistent with the override, the underlying doctrinal purpose of affording the defendant due process. I mean, do we have to wait until after the conclusion of the state's case to know that they can't prove it if we know that these guys can't testify? I certainly hope not.
Mr. Byrne, do you want to speak to that at all? If we're even
I-
talking about a material issue, can the state prove its case without Rosen and Donahue?
I mean, we're under, prosecutor ethics to continually review our case as we get witnesses and evidence and different facts come up. And so if we couldn't prove our case, we have to be able to review them. Might have to dismiss it. It happens all the time in other prosecutions and happens in this courthouse that we can't prove something, we no process it. So as it comes through, we'll continue to abide by our ethical, obligations.
Your Honor, by indicting Mr. Clark, they have represented to the court and to us
At the time of indictment.
and the world that they can prove the case. And they may have a letter that tells them they can't. And if that's true, that's important.
As I understand it, that letter was saying potentially that they couldn't testify before the special grand jury. And I guess there's a question of whether they might have another letter at some point in the future indicating whether that's going to be the case for trial. So the argument evolves, right?
And just to clarify on this letter with the DOJ, we're not getting into the substance of it, whether it was a denial of grant, because that gets into the substance of what's going on, just that it's generally about TUI processes.
Sure. All right. Well, I guess as indicated, I'll take a second pass at how these two requests might fit into Brady. And as to the second issue, we'll start just with the in-camera review, seal the documents on any correspondence with White House counsel's office, as that's what was requested in the motion to compel. And why don't we start there? If you can have that to me, if you can compile it. And then after I've had a chance to review it, then I'll make the findings, whatever I need to make in the written order addressing all of these issues.
And Your Honor, if I may be so bold as to suggest an in-camera review of any TUI correspondence with the other agencies as well.
Well, let me see where Brady falls in that, where it falls first. I think that I'm stuck more on the legal issues there.
Okay.
All right.
All right, Judge.
And we'll go from there. Anything else then on this motion to compel?
No, but I wonder if
Otherwise-
we might approach the bench to discuss the motion that I filed earlier this week with a request to file under seal.
Sure, that's fine. We can do that. Before we do that, just we can wrap it up though if there's nothing else.
Well, when do you want the correspondence to you filed under seal?
I mean, how long do you think it'll take you to compile it? If it's two pieces of paper,
Those two pieces of paper, but if you wanted to, yeah, that shouldn't take that long.
I'll be here tomorrow too.
Okay.
And I think you can just do that, a physical copy in an envelope, and let's say COB by the end of the week. All right. Okay.
Thank you.
If there's nothing else, then we'll be off the record.
All right, thank you.
Continue.
Would you mind putting up there for just a second? Yeah. So I sent this to Will.